predicated on lack of subject matter jurisdiction, on breach of Sowore and Dr. Malcolm's constitutional right to fair hearing, and lastly, on improper evaluation of evidence. The matter has had a very checkered history from 2019. It was delayed for several reasons. But thankfully, to the glory of God today, we have finally come to just the last but one bus stop in this matter. Because today, I am very happy to announce that our appeal was heard and judgment has now been reserved to a date that is to be communicated. You are also aware that after the hearing of the appeal, I did invite the attention of my lords to the INEC timetable regarding the time for primaries, in pleading with the court that in fixing a date for judgment, that date should be taken cognizance of. And thankfully again, my lords were very gracious to say that they are aware of it and that they know what to do. So we have argued the appeal, but I want to inform you that the obstacles to the hearing of the appeal on the merits were defeated today. INEC, that is supposed to be an unbiased umpire, filed what they call or tag a brief of argument. So when you open the next page, you see preliminary objection. And then they did not respond to any of our argument, they did not respond to our case. INEC agreed with us that the lower court had no jurisdiction. But the same INEC, speaking with the other side of the mouth, said no. Even though they agree with the appellants that the Federal Court had no jurisdiction, they asked that our appeal should be struck out, which we had replied to was unprecedented. And that was why, if you were in court, you would have seen where or heard when I told my lords that the second respondent INEC filed a strange process. And that strangeness, again, was manifested today when even the lawyer to the first respondent INEC, Leonard, also took quarrel with the practice that INEC adopted in this matter. So INEC had no option, but was forced to withdraw their objection, asking that Sowore's appeal be struck out. So that process by INEC, that application by INEC no longer exists. Secondly, Leonard had also, in his brief of argument, raised what is called a preliminary objection. Very interesting. When the matter came up today,